Mishcon Academy digital sessions.
Hello everyone, I hope everyone can hear me. It's a great pleasure, privilege to welcome you to this Mishcon Academy digital session. Let me introduce properly Joshua Rozenberg. He is, as he's described in one of the reviews for this book, a preeminent legal correspondent and Britain's foremost legal journalist. Joshua is a full-time journalist and was appointed a QC, an honorary QC in 2016. After taking a law degree at Oxford, he trained as a solicitor, and he's an honorary master of the bench of Gray's Inn and a non-executive board member of the Law Commission. He has a long and distinguished legal journalist career, working for the Daily Telegraph, the Guardian, and the BBC, and has presented the BBC Law in Action programme for very many years. Let me just, with an introductory question, understand why you came to write this book. What motivated you to write this book?
Well, I was approached by a publisher, by Bristol University Press, and they have a series of books on social issues, and they wanted to expand their coverage of law, and they wanted a law book that dealt with social issues. That came at the same time, really, as your client, Gina Miller, challenging the arrangements under which the UK could give notice of its intention to leave the EU. And I thought that putting all those together, a book about how judges make law. So it's a way of just explaining what the judges do, how they do it, and under what framework they operate.
I'd like to start actually with the first Gina Miller case, if I may. I was surprised at the time that lots of people that spoke to me before that case was heard were saying to me, "You're not going to win, James." And they weren't talking to me about the legal merits of the case, but they were talking about the politics of the case.
I think the judges are quite sensitive to public opinion. They may well go against it, but when they do, they think about it. I thought that they might think that they would be depicted, as indeed they were, as blocking Brexit, and that they might therefore not grant judicial review. But they did. You know, the interesting thing about judicial review is however often the judges say that judicial review is not about the merits, it's a process. They're looking at whether ministers acted within their powers. People think that at the back of it there is some political thought, there is some political concern about what this would mean.
Let's get straight to that, then that sort of, at the centre of the book, the balance between parliamentary sovereignty and intervention of the judiciary. There was a point in time when Liz Truss failed to come to the defence of the judiciary that you talk about, where we have the famous Daily Mail headline. And you also have, throughout the same period, the very organised, persuasive campaign, if you will, of policy exchange through its Judicial Power Project that feeds into this debate. Where do you think we are in that seesawing of the issues?
The book had to be finished by last autumn. We just were able to squeeze in Miller 2 into the proofs. But what I didn't know and what I didn't have time to include was the reference in the Conservative Party manifesto in December of last year. The Conservative Party said it would ensure that judicial review is not abused to conduct politics by another means or to create needless delays. He is saying that the judges are behaving like politicians, and here are the politicians in the Conservative manifesto saying, well, we're going to put an end to that.
In that discourse, where we started, as I said, with the Daily Mail headline and the failure of Liz Truss then to stand up in defence, there still seems to be quite a lot of offstage criticism. And before she became Attorney General, Suella Braverman, for example, wrote about the two Miller cases and described them as the latest examples of a chronic and steady encroachment by the judges, that powers repatriated from the EU would mean precious little if our courts continue to act as political decision maker, pronouncing on what the law ought to be and supplanting Parliament, etc. Now that was before she was appointed. But I think the mood still exists.
It certainly does express a feeling within government. On the other hand, I mean, look at it a bit more closely. This week, the High Court judge, Mr. Justice Lewis, refused permission to an enterprising businessman who wanted to challenge the coronavirus regulations. This isn't that he threw out the case, he didn't even allow this man, Simon Dolan, to bring the case, despite the fact that a lot of people are uncomfortable with the lockdown regulations. And he gave various reasons for that, which are all published in his judgment. You can boil them down to saying that the government did not exceed its powers, and that however extraordinary the constraints were, they were proportionate and within the government's powers, and you might say within the government's duty. So there was no problem there. There has been an appeal brought by Chris Packham about the high-speed rail link, HS2, and he was refused permission in the divisional court earlier this year. The judge took the view that the whole high-speed rail link had been, first of all, approved by Parliament by way of legislation, and secondly, the subject of inquiries, and that it wasn't necessarily in the public interest for the courts to block it just because certain individuals, including Chris Packham, were against it. So I don't think that the courts are thwarting the government's ability to operate.
I'm going to turn to some questions that have come in. And Ursula Smart has asked about some of the cases you've written about. She talks about the Conjoined twins case. You write quite movingly about those cases, the cases that involve such difficult decisions for anyone involved in them, either the people bringing the cases or defending the cases, and particularly the people having to make decisions about the cases.
The Conjoined twins case was one which was particularly difficult for Alan Ward, or Justice Ward, as he then was. To summarise his decision, the decision of the courts, you had to cause the death of one conjoined twin in order to save the life of the other. And you had Roman Catholic parents from Malta who wanted to leave things to the Almighty. If the courts had not intervened, both twins would have died. As it was, one died inevitably and the other survived. And the other case you may be thinking of is the Charlie Gard case. And Charlie Gard was also a child who had no prospect of life. And the question there was what the courts should do. And the courts effectively authorised the withdrawal of life support. And of course, the child died. And this was against the wishes of the parents, naturally, but they chose publicity. And the case grew into an international concern. The Pope got involved. The United States, people in the United States got involved, completely misunderstood what the case was about. So there was huge misunderstanding of the role of the courts, huge misunderstanding of how judges worked, and huge misunderstanding about what was in the child's best interest, which is obviously what the court was seeking to establish and deal with.
The results of the Gina Miller cases, especially the Corrugation case, were largely unexpected in Parliament and sent out shockwaves in the political world. Do you think the case has made a significant adjustment in the balance between the courts and the executive, or has it merely made ministers a little more careful?
I think that the circumstances at the end of the last year showed the Constitution becoming unbalanced by what was going on in the House of Commons, by the government losing control. And I see what the courts did as restoring the balance, resetting the balance. Yes, it was a tremendous shock, but on the other hand, it does show how in an unwritten, or at least uncodified constitution, how flexible it is. You know, the courts say that Parliament was not lawfully prorogued and therefore as a matter of law, it's still sitting, and it returns the next day, and they cross out prorogued in their records and put adjourned, and everything carries on. Despite the fact that, you know, you're entitled to claim this as a great victory, it was merely judicial review, acting as it should. It was merely the courts saying that powers that were exercised by ministers had to be exercised within limits, and adjourning or suspending Parliament for 5 weeks was unlawful. It's as simple as that.
The other take on it is that it was ridiculous. And the fact that our constitution is so uncertain illustrates actually the weakness in the system rather than the strength of the system.
It's a system which depends on balance of powers between the executive, the legislature and the judiciary, between the government, between parliament and the judges. But in the end, and this is what links the two Miller cases, this was the courts restoring power to parliament. So this was the courts shifting power from one side of the constitution to the other. And they were doing so because they believed that that's where the power should lie. And if you look at it like that, power should lie in Parliament and ultimately in the House of Commons, I think that's how it should be.
I worry sometimes that our constitution is too distant from the people, the general public, and also a failure of the people who engage in the constitution really to have made it accessible in a way that it should be.
You know, some people say it would be nice to write the constitution down. Now, I think that's, first of all, impossible, and secondly, undesirable, because I think the flexibility of our unwritten constitution allows to shift the powers in one direction if they go too far. The judges could do more. One of my complaints about how the Divisional Court, the High Court, handled Miller 1 is they didn't explain in the judgment or the summary that all that was necessary for the case to be dealt with was for Parliament to pass legislation. Now, if the judges had explained that clearly, it might not have stopped the headlines, but it might at least have helped people to understand that this wasn't the judges blocking Brexit, this was the judges saying that legislation was required, and as a matter of principle, and legislation could be got because this was government policy and the government had a majority in Parliament.
Some very interesting questions on exactly that thing. The problem with the Gina Miller case and the proroguing Parliament, it was widely perceived that Lady Hale and her colleagues had allowed their own political prejudices to intrude. The point is, public faith in the courts has been gravely shaken by Lady Hale's findings in the Miller case, and this cannot be helpful in a democracy.
Yes, it's quite true that Lady Hale has commented on some of her decided cases rather surprisingly. Is it political? Well, they have strong views, but I don't think the judges are part of political. And one of the things that I quote in the book is the fact that the judges were rather pleased about the fact that the newspapers in Miller 1 who tried to predict how the judges would decide the case according to their perceived views on Brexit got it completely wrong.
What role, if any, does diversity within the judiciary play in the way it deals with some of these issues? Does Joshua think that a more diverse judiciary would tackle or decide some of these cases differently?
If you say, should the courts reflect society? Yes, of course they should. Now, I'm totally in favour of enabling people to prove their merit from whatever background they come from. That's absolutely excellent. But if you say to me, should we have all women shortlists, for example, then I will say no, because I will say that appointment to the judiciary must be on merit. And if you ever lose that principle, then you are damaging the status of minorities who have made it to the judiciary. There is one exception to that, which is a provision that says if you have two people of equal merit, then you can select the person from a minority, and the justification for that is that person probably had to work harder in order to get to where they are.
In terms of just looking at the judiciary going forward and the legal system going forward, what would be your three top tips for modernisation and further raising of the esteem of the judiciary in our country?
But I think, carry on as they are, explain what they're doing, and don't sacrifice anything. Keep independent. Don't worry about what people like me say, but keep doing the day job and keep on judging. And as I say in the book, enemies of the people, no, they're the best friends we have.
You've ruined the ending, but the journey to the ending is absolutely fantastic. And I just commend the book again to anyone listening today. It's a great read. It should be essential reading for a much wider audience.
Thank you very much for inviting me. I've enjoyed it a lot. Bye-bye.
Bye.
The Mishcon Academy Digital Sessions. To access advice for businesses that is regularly updated, please visit mishcon.com.